Good afternoon, ladies and gentlemen. We welcome you all to the next session of the day, that is Digital India Copyright Act, redefining the future of creative works. We have eminent speakers for the session to be moderated by Mr. Trevor Fernandes, who is the Vice President, Government Affairs, APAC Motion Pictures Association. To take it forward, we hand over it to Mr. Fernandes. Over to you, sir. Thank you.
Thank you. Greetings all. As mentioned, my name is Trevor Fernandes. I'm the Vice President of APAC Government Affairs for the Motion Picture Association. I'm joining you today from Singapore. It is great to be with you all today to moderate this virtual panel, which again is called Digital India Copyright Act, Redefining the Future of Creative Works. And I hope everyone is keeping safe and healthy. The MPA represents the interests of 6 international producers and distributors of filmed entertainment, all of whom have important and growing commercial portfolios in India. All around the world, we promote and seek to protect the intellectual property rights of our member companies and to conduct public awareness programs to highlight the importance of content protection. These activities have helped to transform entire markets, benefiting film, television, and now the streaming industries in many countries, including foreign and local filmmakers alike. The growth of the India market in recent decades has been spectacular in this regard, across both linear and digital deliveries, and we strongly believe that our work makes a positive difference to this market. Now in India, where we once again have a direct operating presence, the MPA is proud to take up new challenges and opportunities posed by a global digitized market and accelerated by the pandemic. And we thank our friends at FICCI for organizing this important panel discussion to share ideas on the same. Today's discussion brings together a wide range of views and considers both Indian and global perspective. Not coincidentally, it also comes against the backdrop of consideration by the Registrar of Copyrights within the DPIIT, who has posed a short yet incredibly complex question to stakeholders in light of both digitization and the pandemic. And the question is, quite simply, whether there is a need for amendment in the Copyright Act of 1957. As you may be aware, the Act was last visited in a meaningful way back in 2012. So presumably, almost a decade later, the consideration by the registrar in 2020 and beyond is justified. But this is also not a time to rush changes without very careful deliberation and policy calibration. There is much work to be done if India seeks to redefine copyright law for the global digital era. With that said, let's get right into today's panel discussion. I will start with a quick introduction of each panelist who's with me here today, and then we'll get into an initial round of questions and remarks. First of all, joining us from Krishna Associates, Mr. Ameet Datta, who's a partner with the firm. Ameet has over 20 years experience as an IP litigator and lawyer, and he has advised leading Indian and international industry clients, including numerous MPA members, on content creation, protection, and monetization. And he is actively engaged in policy reform around the copyright sphere. Joining us today from Viacom 18, Mr. Anil Lale, General Counsel. Anil's leadership spans across functions, including IP management and protection for the network's many diverse lines of business. He has been part of the media industry in India for over 13 years. Mr. Ritesh Khosla joins us from Sony Pictures Networks India, where he is Deputy General Counsel. Ritesh holds more than 16 years of experience in IPR and commercial transactions, legal strategies, anti-piracy, compliance, and regulatory across the Sony Entertainment Group in India. And last but not least, my colleague, Mr. Uday Singh, who is the Managing Director of the Motion Picture Association India, a man who hopefully needs little introduction with his long and illustrious career in the Indian media sector. He's been representing our collective interests across the copyright and content protection space for the last 10 years and has extensive commercial experience in M&E prior to that. So I thank you again to all of you for your time and interest in participating in today's panel. Ameet, if I could start with you to get the discussion flowing. Could you give us your broad suggestions for improving enforcement against digital piracy and of particular importance, making enforcement more timely in this new global digital era. What can be done, in your opinion, ahead of the legislative changes that are being contemplated, meaning what can industry and government collaborate to do right now? And then further, what requires potential changes to the Copyright Act in your view as we look down the road? Ameet, sir.
Thanks, Trevor. Good morning to everybody, including my esteemed panelists. Thanks for the question, Trevor. That question is doubly loaded. I see that you loaded both barrels. The government of India loaded one barrel, and you loaded both barrels. I think, and we could talk about it for the rest of the day, but I think, one thing that the COVID pandemic has this sort of black swan sort of event has brought us to a realization that when we need to get things done, they happen. Multiple diverse entities are spread across the world, work seamlessly together over the digital space, working from homes. Things that were not possible, conducive, or convenient pre-COVID, have suddenly become possible. And that to me is an indication where, and why the Copyright Act as well, copyright law in India needs to step into the so-called digital domain. And we've been talking about, the Copyright Act steps, stepping into the digital domain for a long, long time now. But I think, with everything going digital, including a greater focus on digital piracy, it's overdue that the Copyright Act also now incorporate modalities to fight in digital piracy from a digital perspective and not from a physical world perspective. We've stuck for far too long in the physical world. As you know, Indian courts have, particularly the Delhi High Court, has been very, very innovative where site blocking actions, are concerned, and the MPA has taken a tremendous lead in helping to develop, helping the courts to develop their jurisprudence. We've gone to dynamic injunctions, and recently the dynamic injunction perspective has gone to another sphere altogether on the sports broadcasting side, where rather than identifying new entities or new variations of websites or online resources and having a court pass an order, all you're required to do is file an affidavit now, and which will be deemed automatically included within the order. So even that little process is not required. But I think, all of that has its limitation. And I say limitation in terms of the inconvenience that rights owners are put to, the money they spend in tracking, identifying, and then persecuting or prosecuting entities, chasing them all over the globe, monitoring them, etc. All of that is something that is time consuming and needs a lot of focus and a lot of resources. Personally, what I'd like to see in the Copyright Act is a method and ability for administrative site blocking, where in nodal ministry, when identified and advised of actual instances of online piracy, can take action to administratively block websites. Now, again, this is a topic we've talked about for a long time, because Section 69 of the IT Act allows for such blocking, unfortunately, not on copyright infringement grounds. So what I'd really like to see is the Copyright Act bringing in processes and an ability for rights owners not to have to go to court all the time, but have an ability to have an administrative site blocking perspective. Across the board, I think, not to take too much time for opening remarks, but across the board, I think the Copyright Act needs to be overhauled in a substantive and significant manner. Starting off with the digital space, I'd like to go back to the simplicity of the 1 and the 0, and have simple language and have non-ambiguous clauses and provisions which make it easier. There are two reasons why the Copyright Act needs to be updated. One is to be able to protect intellectual property more efficiently in the digital space, which is one of the reasons why India has acceded to the WIPO copyright treaties after all. But equally, it's important to update the Copyright Act for the digital space because we need to prevent the misuse of IP under the nomenclature of outdated or older provisions. A clear example here, for instance, would be Section 31D, which is, which was always intended to be extended to traditional broadcasting, radio and television, and now is, sought to be extended to online streaming when it's questionable that the legislature did not intend it. And under that sort of condition, you are bound to do more harm to the interest of copyright owners and to the industries as opposed to help. Because if the provision did not oversee those acts, then it obviously did not deal with balancing between the ownership interest and the interest of, say, exploiting platforms or utilizing platforms. So these are just some of the kind of ideas I'd like to throw out there, and then as we discuss, I guess we can go ahead and talk more about it.
Yep, excellent. Thank you, Ameet. A lot of great food for thought in this panel discussion as we proceed. Turning to Anil, what are your thoughts on the overall challenges of civil and criminal proceedings in India against digital pirate site operators based on current law and enforcement resources? What would you like to see by way of potential legislative changes to aid online enforcement moving forward? Anil? I think you're on mute, sir.
Thank you, Trevor, for the question. And I think Ameet has already covered most of the points that are there to talk about. It is time that we acknowledge that piracy is more than just infringement. Right now, what is happening is that the copyright law is enabled to deal with normal infringement. What is piracy and how it is different from infringement? In my mind, piracy is the business of infringement, and the websites and apps which predominantly peddles the infringed content is what is hurting the creative economy. So it is time that law wakes up and realizes that piracy is a real threat to the creative economy and is destroying the creative economy or eating it from inside. Also, what is happening today is that these pirates have no face and no territorial boundaries because of the digital space that we are in right now. So they can operate from any country in safe havens, or even within India also there are when the law here right now provides for criminal enforcement, you have to go to the local police station and file a complaint there, wherein it becomes a difficult proposition even if the pirate is within India also to get it enforced, get the police to cooperate between states and do an enforcement action, and all those things is a very elaborate process today. Even when we are looking at blocking of the sites, as Ameet said, we have to go to courts today and we have to take John Doe orders. Now it is evolved into dynamic injunctions where at least the courts have put a process in place where we can just add the variations of the sites, because it's like the game of whack-a-mole when you deal with pirates. The website that you actually shut down or just get it blocked, they just come out with a variation and it is back and up and running again in no time. So it is very difficult to stop piracy, and the problem is that when there is a movie that's to be released and it gets leaked out, or there's a program that is to be released, it leaks out, or immediately after the program is broadcasted, it comes on a pirate OTT, the actual revenue that a broadcaster or a producer is supposed to earn is being eroded. So going to court, taking, even filing an affidavit, getting a further injunction, that takes time, and lesser time than that is taken by the pirate to come out with a variation site. So, between Viacom 18, Sony, Star, and MPA, obviously, we had, we even tried to do a public-private partnership by setting up the MCDCU, which is Maharashtra Cyber Digital Crime Unit, to fight piracy. And it has also given a lot of, efforts have gone into it, and some results have come out of it. But again, it is not the silver bullet for piracy also, because it is, again, it is one state. And when you look at it, if this kind of units come up in every state, is that the answer? Again, the problem is interstate cooperation and all those things. Apart from that, if you look at it, it is not just India from where the pirates are operating. How to reach out and cooperate with agencies outside India is also a question that we need to get an answer for. And to top all that, right now, today, the fight against piracy is mainly a one-person game. Like if Viacom 18's property is being pirated by pirate side, I'm not talking about just infringement, I'm talking piracy here. Viacom 18's content is getting pirated, then it is Viacom 18's fight against that pirate. But everyone is doing their own individual fights. So that is where that nodal agency or the central agency, which can come through law, the establishment of that can happen. And again, there can be a public-private partnership to have a common infringing website list and all those things. And all the content owners, content creators have to come together with this kind of an agency, public-private partnership cooperation, and instead of going to courts and wasting judicial time, it may be the government may be able to help in fighting piracy more efficiently if this kind of a private public partnership can be taken to a national level. And also, it is important for this kind of a process where the government can also engage with similar agencies outside India, so that there is international cooperation also in the fight against piracy. And this is actually a big issue, as in piracy is not just piracy; it funds illegal activities. So it is much more than hurting the creative economy. I think it is a much larger issue which needs to be tackled, and it's high time that the government also looks into something like this.
Okay, great, thank you, Anil. Continuing along, Ritesh, if I may turn to you, and continuing on this theme, more or less, as part of a global group, Sony is well positioned to leverage Indian content as a digital export opportunity all over the world on behalf of India. But this, of course, depends on maximizing the opportunity for your content investments here in your home market. How does Sony see copyright law as a tool to improve your content monetization opportunities in India, especially with the rise of VOD online seeing substantial growth, but also, as the panelists have been mentioning so far, pirate sites also seeing substantial growth using your and everyone else's content? Ritesh, over to you. If you can remember to unmute yourself, thank you.
Yes, good afternoon, everyone. It's very interesting when I talk to my business leaders of what we are doing to deal with piracy, because that's one of the major concern areas which has now find its ways in the minds of the business people as to what we are doing about piracy. Until 2 years back or 3 years back, at least at SPNI, Sony Pictures Networks India, legal team was doing proactively some anti-piracy measures. Now there's business pressure to do a few things, and that's where I think piracy has had the greatest impact, as one can imagine, if the business leaders are involved into some of the decision making or to deal with the piracy. This is by far eroding the revenues, be it India or be it international. More international space, because in India the subscriptions and be it on the digital or television side are quite cheap. Of course, the Indians are getting access to all the international websites and apps which are pirated. They get to download and watch all the content. But I think internationally we are also getting a big hit. So I think Ameet and Anil have spoken rightly about the efficacy of our Copyright Act to deal with piracy. And I think, in my view, just to add what they said, the time has come that the Copyright Act should be overhauled, and in the entire overhauling, piracy needs to be defined. It has to be distinguished from simple infringement. Piracy is at industrial scale, and it is done to deny the government of their legitimate revenues, and of course erode the revenues of stakeholders and players like us. And in that sense, the government should look at from the lens of an economic offense. It is a big economic offense. Also, I think one of the problematic areas in our Copyright Act is, of course, Section 52(1)(b), which talks about the transient and transient storage of data and performances in the technical process of communication. And I think that has to be struck down because it creates complications. I will talk about some of the other points that we should we typically look at leveraging the Copyright Act, be it in India and in international space. Now that we have talked enough about piracy, these may be the softer points, but one thing that we are told that the business needs certainty. When we go and tell the business that we do not know, but we need to make a provision for this payment and for that payment, and that's where the business people get rattled to say that, you know, what the lawyers are doing. And there are a couple of provisions in the Copyright Act which are quite questionable, or at least there is no clarity. And of course, the first one is the provisos to Section 18, where the cinema halls are excluded when a movie is exhibited there for the payment of royalties. Now, of course, we all know the genesis of this, but I think from a broadcaster point of view, the way we see it, that if a movie which is primarily produced for theaters, the royalties are not to be paid to the authors, what about the television programs which are made for television? What about the web series which are made for digital platforms? They should be meted with the same kind of treatment. And even for this exception of theatrical distribution of the movies, is not going to hold true even after the post-COVID scenario. The movies are now getting released on OTT platforms. Even now, and I think this trend is likely to continue. And therefore, I think this is one area that is of increasing concern, and it needs to be revisited. The second point is, you know, the producers of the content. We call ourselves the producers of the content. Not only we are producing for our television channels, we're producing it for third parties. We are OTT a stakeholder, we are television stakeholder, we are doing into theatrical distribution, we are doing all sorts of things. And I think it's very important. Sorry, my screen has gone off into the silent mode. Let me return. Sorry about that. I forgot to tinker with my mouse to remain on this. It went to the silent mode.
Quite all right.
So yeah, so we are investing a lot of monies into the content, and it is a fair expectation of the investor that he should be able to control all facets of that content which are produced. And the problem lies in Section 17(b) of the Copyright Act, where you can be the owner of the cinematograph film, but you cannot be the owner of the underlying works. And I think that is one area that needs to be looked into when the legislation is going to be revisited. The next is, of course, which is quite favorite to all the lawyers working in the broadcasting and OTT fraternity, would be the royalties payable to the performers. You know, the curious interpretation of the word live in the definition of performance, how it is being interpreted and how it is being now forced upon by some of the copyright societies is quite questionable. And of course, that in fact gives you a lot of uncertainty and adds to the cost if it is to be upheld eventually. And of course, then the royalties payable to the performers. I mean, there are two points to it. One, who are entitled in a cinematograph film, who are entitled for those royalties? All the performers or the key performers, the marquee performers? There's no clarity. Unlike assignment of a copyright for the for a sound recording, you know that you have to share the royalties in equal attribution to the authors as well as the music label. But there is no clarity on this. And the other facet to this is, of course, no, I think I've covered both the facets. And I think one soft area where, again, we need to look into from a futuristic point of view is the data sets and databases. I've had a couple of discussions in other forums as well, where I think companies, including the content companies, are increasingly invest in artificial intelligence and machine learning. Now, those data sets and databases, currently, I think we seek to protect them under the literary works, but I think that's quite outdated approach. I think the data sets and databases need to find its own place in the copyright as a separate species and class of work. And then I think this debate which is going around the world of whether artificial intelligence and machine learning creating copyrightable works can those be owned by a non-natural person? And I think the time has come that this debate needs to conclude in favor of artificial machine learning. We all know the reality, and I think for example, companies should be regarded as the authors of those works because they simply own the artificial intelligence and machine learning. And I think these are some of the areas which can be leveraged by big producers and big broadcasters and OTT companies, which can lead to the maximization of the revenues.
Okay, excellent, thank you. We'll definitely come back to the AI theme in the second half of our panel discussion, because that is absolutely a critical component of this if we really want to do something that's sort of more far-reaching when we talk about changes to upgrade copyright for the digital era. Before we continue, I did want to have at least one more question on the content protection track for Mr. Uday Singh. Uday, as noted in MPA APAC President Belinda Louie's welcome address earlier today, the MPA works closely with ACE, ACE, which is the Alliance for Creativity and Entertainment, to protect film and television content against piracy all over the digital world. A key ACE priority in India has been what has been referred to as the Telegram Monitoring Project. And this is meant to be an example of voluntary collaboration efforts without having to go too far down the path of legal actions or legislative changes. As we all know, digital platforms such as Telegram clearly hold many of the keys to a global digitized market for our industry's content, products, and services. Uday, if you could tell us more about the so-called voluntary measures in India with platforms such as Telegram, how they've been operating in practice, and their importance to the industry during this time of digital transformation and pandemic, that would be great. Uday?
Thank you, Trevor. Let me take one step back and talk of some of the problems that the earlier panelists have raised, primarily about the shape-shifting monster that piracy is, that it keeps morphing and going into multiple locations. The second was it's multi-jurisdictional. The threat is not in one location because the pirates have morphed into operating out of multiple areas, as we've seen with some of the leading sites. And the third issue I think that came up was what are the kind of remedies that we could follow. And I think while we've looked at the judicial and the need for administrative remedies and the inclusion of MCDCU and the dynamic injunctions in the Delhi High Court, I think this, as we all recognize, there's not a single bullet that can take care of this problem right across. ACE, I think, has been set up as an answer to this multi-jurisdictional and shape-shifting problem, where it kind of addresses the same rogue site in multiple jurisdictions and tries to find what could be the best way to kind of stimulate a legitimate marketing environment, market for our content businesses, and also to kind of make it more difficult, or shall we say, raise the cost of the pirate from doing business and reduce the cost of our legitimate players from, the harms of piracy. The only point I would like to add on the economic front of piracy that was raised by one of the panelists is there's also a social problem, because a lot of these sites have malware and identity theft, and all kinds of things that are embedded. So when you're downloading that software, you're also getting all kinds of other problems and unwanted problems, which you can deal with. So I just wanted to kind of add on that economic platform problem. Coming to another opportunity, as you mentioned rightly, is this whole voluntary process. Multiple jurisdictions have tried it in the past by having voluntary measures in place. And I think what we have been able to achieve with this Telegram monitoring project is, I think, a very good start in that direction. As you know, Telegram is a peer-to-peer service, much like WhatsApp. The only difference is it allows about 1.5 GB that can be transferred from one person to the other. It also has what it calls the super groups, where about 200,000 people can actually become members of a particular channel, and it allows that broadcasting of that channel to go to unlimited number of people. It has about 400 million users on a monthly active monthly users. And if you actually look at what they claim is that if they are if they are notified from a copyright holder, then they will definitely work towards bringing removing that infringing content. So the Telegram monitoring project was set up by ACE to be able to look at how we can address the problems of sharing on the Telegram platform. There were multiple channels and multiple users, and with this large user base, it can be a little more complex. So how could you address this problem in a voluntary manner, where you could have an arrangement where you could send notices to Telegram and get some results? I think if you look at what the ACE process was basically mine the data, look at the channels which are actually doing, which are relevant to our members and relevant to ACE. As Belinda mentioned in the morning, the newest addition to ACE is, other than the major content providers across the world, is also Apple Plus. Apple has just joined the ACE coalition. And I think what once you find a relevance, they've been able to actually extract and identify the information where the channels are actually, where the infringing channels are. Then they issue bulk notices to these channels, right? So that they can get, so they know that somebody's watching them and there's a level of disruption that can prevail. And then we monitor and track the responses that have been sent out. As of August 26th, the project tracked about 1,100 different channels on Telegram. They sent out about 12,000 notices, and they targeted about 193 targeted channels who were actually infringing. 58 channels were taken off. 57 channels complied with the takedown requests, and 62 channels partially complied with the takedown request. So approximately 82% of the notified infringing messages have been removed, and then follow-up notices sent to those who are partially doing it and partially not fully taking off those infringing materials. Now, this actually sets up a very interesting proposition, which is an additional tool in the arsenal to be able to have voluntary arrangements. It's a beginning of a very good arrangement where we need not go to either the courts or look at the policing mechanisms, where just between the copyright holder and the platform, you could actually enter into an arrangement. I think similar arrangements have been set up in UK and other jurisdictions where on voluntary mechanisms have worked. But there again, it was blessed by the government, who played the role of an honest broker between the copyright holders and the various platforms to be able to bring about this kind of an arrangement. I think if this works for Telegram, which is one of the biggest problems in India, we could always look at the good part of this is a scalable model. We can immediately scale it to a larger number of infringing sites, and it could also get extended to more platforms who want to get into this kind of a voluntary arrangement. So I think this is another additional tool to disrupt the pirates' shape-shifting monster, or the pirates' hydra-headed number of sites, by finding a simpler voluntary mechanism.
Great. Thank you,
Back to
Uday.
you,
Yeah, thank you, Uday, for that very good overview. No doubt we'll come back to the content protection and digital piracy theme. I did want to make sure we spend a few minutes on some copyright and IPR related topics that aren't necessarily directly related to content protection. Ameet, if I could come back to you and tap into your expertise around government thinking. Question is your thoughts on how the government gets the balance right as it seeks to look at copyright policies now and going forward. From my personal perspective, and from what I've certainly seen in other jurisdictions around the region, COVID certainly is an opportunity to sort of prompt carefully calibrated changes that ought to happen anyway. And I think you may have alluded to this, this notion that there might be a stack of things that a government wanted to achieve anyway. And COVID certainly creates both an opportunity and an impetus to act on legislative changes, sort of if not now then never kind of mandate. At the same time, certainly with something that is of course understandably emotional and impactful as a pandemic, there's also a risk of reactive changes coming out of this process, and there's always the risk that legislative changes in particular, might be rushed, and that ends up setting negative longer-term consequences, and after a number of years puts us sort of in no better place than we were prior to the pandemic and the impetus for change. So in a broad sense, what would be your advice to all of us as the government sets down this path of reevaluating copyright for a global digitized era, particularly as what you suggest, really copyright needing a fairly comprehensive overhaul? How do they sort of strike the right balance between these sort of immediate changes, but not rushing through and still giving things due consideration?
Thanks, Trevor. I think firstly, India really needs to take a very careful and calibrated look at the Copyright Act and realize that far from being aligned with international processes and international practices, well, I quite understand that the jury is out on the term international process or international practice where copyright law is concerned, but in large areas and large themes, we are not aligned with the international system. And as a first off safe ground, a travel posture where amendments are concerned, alignment with the international system is important. Now, what do I mean by alignment with the international system? Now, internationally, and I go back to elements of Ritesh's discussions on the aspect of ownership, royalty rights, etc. And I'd be the first person to agree that that construct is probably the most unnatural thing that one can find in a Copyright Act. It's not natural. But one thing people would realize is there's a reason we got there. The reason we got there is that unlike in the West, which actively respects copyright as a bundle of rights or bundle of distinct rights and preserves the distinct identity of underlying works that are incorporated in films and recordings, etc., India stopped doing that. India started looking at collective or derivative works or neighboring rights or the resultant consequences of the confluence of underlying rights as the only existence. And when we did that, we did a silent, unacknowledged violence to the copyright system in itself. That meant that copyright owners who sourced and paid for underlying works were, in a sense, themselves barred from monetizing the underlying works when their collective works were being exploited. By way of example, it prevented a film producer from separately monetizing and collecting royalties through copyright societies. Forget about authors for a change. Just go by owners. It barred and literally prohibited a copyright owner from being a part of a copyright society and collecting performance royalties from the exploitation of the underlying works as a part of a film in a cinema hall. You go to Singapore. In Singapore, the local publishing copyright societies collects royalties when a film is exhibited in a cinema hall. And why did that not ever happen in India if we have a bundle of rights and copyright and distinct right theory? Because if our practice was so disaligned or so off the rails that we came to a system where neither the stakeholders were recognized, neither were the owners who paid to and commissioned works were able to monetize their underlying works and their bundle of copyrights. So we came to this unnatural position where, regardless of ownership transpiring, monetization or remuneration was thought by the policymaker as being an adequate contribution to the recognition of different stakeholders. A simple way to address that, to my mind, is to ensure that you recognize, and the Copyright Act stipulates, and sometimes in India I've learned over the last 25 years in the law, it's important to state the obvious. Unlike, I don't know a parallel anywhere in the world where one has to state this obvious. So from that perspective, I think, we need to state this obvious. And so, as for the first theme is align back into the world system. Realize that the world system has worked in a manner, even while there is corporate authorship in America, even where there is 100% buyout in the rest of the world, stakeholders are respected, critical stakeholders are respected, make a lot of money, as songwriters do and scriptwriters do and performers do in that system, and industries boom. So, the international system is a precedent that we don't need unnatural provisions in our Copyright Act, but we can't get rid of these provisions unless you align with what the world is doing and what has worked for member studios in the US and Europe and different parts of the country, different parts of the world. So I think that's the first element. I think that's really important. Secondly, I think what India really needs to do is, when we talk about alignment and when we talk about taking India, the Copyright Act into the future, is to take our treaty obligations exceedingly seriously. We seem to have got used to India, unfortunately, as saying that, oh yeah, fine, we may have a treaty obligation, but as it's municipal law that prevails, and if municipal law is in derogation to a treaty, then municipal law will prevail. It doesn't matter. Well, you sign treaties for the purpose of harmonization, and you have obligations. And those obligations must be taken seriously. And if you don't take those obligations seriously, unlike other countries, India's parliament, as we know, doesn't ratify treaty. India ratifies international treaties by incorporating those treaty obligations and provisions into domestic law. So we must explicitly do that. We must explicitly call out the treaty alignment. There's no point in signing the WCT and having TPM provisions which are diluted to the WCT and WPPT provision. It's not a question of nationalism. It's the question of harming ourselves and harming precious industry when we don't align with this system. There's a thought process to why we align with international copyright treaties or international IP treaties. Not because our arms are twisted behind our backs, but because we realize we can share from the international system and benefit from that system. And I think it's crucial that the second element of consciously and in the spirit and letter of the law, aligning with international treaties is incorporated. One of the biggest provisions in international treaties is the three-step test in the Berne Convention. And if today that three-step test were perhaps to be applied to many of the exceptions and limitations, perhaps in some of them, if not all, India may fail the three-step test that the Berne Convention has applied. And the Berne Convention itself is a threshold criteria under TRIPS as a threshold qualification criteria. So I think, these are the two big call-outs I'd like to make. There are nuts and bolts that we could talk about for the rest of the day. But I think for me, these two call-outs are very important.
Excellent. Thank you, Ameet. Very well said. I'd like to, we've got still about 15 minutes to go. I'd like to come back to a topic that Ritesh actually raised, although I understand, Anil, this is something that you're also quite interested in, and maybe a chance for us to go a little bit cutting edge now in the discussion. With the pace of technological change, we all suspect that we will see more AI-derived works. Ritesh nicely teed that up in terms of definition and what that might look like. Obviously, we're referring to what I'll call non-human created works. These are already happening in the marketplace in many countries. Right now, they could be as simple as short stories, images, or sounds that are already being generated by a computer application. Ritesh also talked about things like data sets and big data, if you will. Of course, as technology accelerates, this absolutely could and should be an opportunity for India to take a global lead in copyright policy, given that India is uniquely placed at an intersection of both creativity and technology within the economy. What are your thoughts, as well as your concerns, if you'd like to state them, about the copyright implications around all of this, such as ownership and protection of such works? Anil?
Yeah. Thank you, Trevor. So I'm going to take this on a very basic level because we are at a nascent stage as far as machine originated work is concerned. The evolution of machines from being tools of creativity, like earlier, maybe we had a Word document, which is also a computer program, but the creativity was actually from cognitive capability of a human being. Likewise, Photoshop, Excel, all those things. But now, from those tools being a tool of creativity, it is becoming, the machine is, or the program, the computer program, are becoming independent creators of work, and it has already happened. That is what the most important thing to recognize is, as in we in 2016 there was a Japanese AI which co-authored a short story which actually had a lot of creativity in it, due to which it went to the second round of a national literary prize. So an AI created by Google is creating music today, and another AI, or the machine which was calibrated by some museum workers, landed up creating a Rembrandt kind of painting, resembling kind of painting, after learning or going through more than 1,000 works of Rembrandt. So all these things are happening as on today, and it has been happening for the last more than 4 to 5 years, where AI has reached a cognitive capability to create its own work. The level of creativity of that work also is becoming more complex and more better day by day, and maybe we can argue that it is still not equal to the cognitive capability of a human being, as an equal to a Rembrandt or equal to a Tagore or whoever it, all those great artists and authors. So when we look at all these things, the questions from copyright law that a machine authored work brings in are mainly two. I mean, these are basic questions that will bring. Who will be the author of the work created by the AI? Can such work, created by AI, have a copyright protection? Now, I will not say that India is behind and has to catch up on this law, because across the world, if you look at it, there are issues that is arising out of law because of the machine authored work. For example, in United States, the Copyright Office has declared that it will register an original work of authorship, provided the work was created by a human being. Now, that is clearly bringing the AI or machine generated work into a domain which does not afford it copyright protection. Whereas in the Europe, the Europe Court of Justice of the European Union has also declared on various occasions that originality must reflect the author's own intellectual creation, and the meaning that an original work must reflect the author's personality. So this means that a human is necessary to create a work, and then only it gets that copyright protection. This is one phase of it. And the other phase of it is, wittingly or unwittingly, countries like India and UK has taken the approach in its law. I mean, presently it is present in its law that in case of any literary, dramatic, musical, or artistic works, which is created by a computer program, the author shall be the person who has made arrangements or necessary for the creation of the work it is undertaken. So the question whether the programmer is going to be the owner or the AI is going to be the owner, this is the third option, which is where a person who actually gets that machine, maybe a machine with cognitive capabilities to create that work, is going to be the author. Why I said wittingly or unwittingly is because the section 2D 6 of the Copyright Act, which basically comes under who all are the authors of works, has been part of the Copyright Act much before even AI getting a cognitive capability or to create its own work has even arrived. So I don't think the Copyright Act has actually, the legislator has actually given a thought about how the AI generated work has to be handled. But whatever is present in the Act today in India kind of gives protection as far as the AI generated work is concerned. Now, the biggest challenge that the world is going to face is there are countries which recognizes copyright created by, authored by machines. There are countries which does not. I mean, the law does not do it. Now, what will this give rise to? There is a complete conflict of laws that is going to happen. And copyright is not a state or a national phenomenon. If a copyright is created, it will only be valid if the whole world gives it that protection. That is why we have all these conventions in place, right? So I think the evolution of the authorship and copyright protection, it is not just a state subject. It has to be a conversation, which is an international conversation. Maybe agencies like WIPO, WIPO, and other agencies will have to pick it up, and it will only settle with some kind of an international convention, which gives this kind of a protection. And maybe agencies like MP and all can play a bigger role in driving this conversation, not only in a domestic forum, but also on international forums as well.
Great, thank you. Ritesh, coming back to you, certainly welcome to share any additional thoughts on the topic of AI or machine learning derived works. And I also wanted to dig in a little bit more with you on the issue of copyright societies. As you know, this is something where the government has been quite keenly engaged in recent months. It'll be great to have your views and the views of Sony. Is there a need for a single society when it comes to copyright collection societies? Is there a need for a single society for a single class of works? Is there a need for a single window for all societies? It'd be great to get your views on that. But if you'd like to start by commenting on what Anil just said around AI-derived works, that would be fine as well. Thank you.
Well, yes, I think Anil has mostly summarized the position on AI and ML. But I like the idea which Anil has propagated, is that it could finally come to our Copyright Act if there is an international convention and we participate in that and we sign it. But India's record, which Ameet I think some time back alluded to, India's track record of implementing these treaties, conventions is not that very great. I would just add that as we speak, the works are being created, and I know for a fact that a lot of these works are being created, and it's gonna just increase in very near future. Opportunity exists because we are invited by the copyright registrar and DPITT earlier. I think there is some kind of a thought process which is currently ignited in the government, that the Copyright Act needs to be relooked. Let's look at those amendments, and I think this particular aspect needs to be highlighted to the government, so that the process of recognition, at least the seed is sown, even if the government doesn't take it up. That's my view. Another interesting thing about copyright societies, I mean, as a broadcaster, I'm delighted that this is being asked. At the same time, we are frustrated as well. The only person who's very happy about it is, in fact, Ameet. He deals with a lot of copyright societies. He's a champion for this area of our Copyright Act. But I can share with you and others my experience of copyright societies. And I mean, we all know this has been a gray area for the longest period of time. IPRS has got semblance, and thankfully they are working very fine. And licensing regime of IPRS has improved. Tariffs are being in place, but we all hear that some of the music labels are trying to now set up their own copyright societies. Then there is a singers' rights, then there are various kinds of literary works societies which are being sought to be established. And that brings to a question of a broadcaster as to how many licenses a broadcaster or any other player, smaller or bigger, has to take eventually. I mean, so many tariffs, so many negotiations, it's leading to, we are heading towards chaos. And I think there should be one copyright society for each class of work. And I also believe that there should be one apex body which should be governing all of that, so that a player like me, who's a broadcaster, who's an OTT player, who's a producer, who's into theatrical distribution, and so the whole gamut of businesses, that person that goes to that apex body and takes all the licenses. And from a copyright society standpoint, look at the nuances that these copyright societies have. Frankly, as a lawyer who has done so much in media entertainment, at times even I get lost in those nuances, and I have to call an accomplished lawyer like Ameet to help us understand the nuances, those who have dealt with these nuances extensively from a litigation point of view. And I think these copyright societies need to understand that they better get their act together and try to streamline this. A lot of copyright societies have come in which are creating problems. Some of those claims, I would consider them being ludicrous. And also, I think one point is that if a smaller player who does not have that bandwidth to hire expensive lawyers or doesn't have an in-house team, it is near impossible for that person to appreciate the nuances of these copyright societies and going from one counter to another counter to get those licenses. Currently, the copyright societies are very happy giving the licenses to the bigger players, and that's where the revenue pie is increasing. But I think there's a much bigger pie that they can target if they simplify the affairs of licensing and regulate themselves under this one copyright society for each class of work, and possibly having one apex body. Easier said than done, but I think that's what is going to be needed in future.
Hey, great. Thank you very much, Ritesh. Uday, we've got a couple of minutes left. I wanted to come back to you with one final question or thought on the content protection line. As you know, the focus for today's panel on copyright, when we talk about content protection, has been around the global digitized area. Yet one of your longstanding efforts for the MPA in India has been to clamp down on old-fashioned camcording of content in cinemas. If you could maybe briefly elaborate on why camcording is still going to be a problem in a newly digitized entertainment world, and what it is that we'd like to see the government taking action in this regard, whether it's within the context of copyright or perhaps other parts of the law. Uday?
Thanks, Trevor. Yes, you're absolutely right. This is one of those Sisyphus things that I've been talking about for the longest time, that we've been pushing that onerous rock up the hill. And I think that uphill battle continues. I think the last was that we appeared before the parliamentary committee, and the recommendations have already gone through. But unfortunately, this has been hanging fire now from session to session. I now learn that the winter session of Parliament is not likely to happen and might get combined with the budget session, which probably gives us the next window of when this probably is going to get addressed. It's a long-standing demand. Basically, we all know that source piracy, where is it stolen from? It's stolen from cinema halls for a large part. And that is one hole that has to be plugged. That leak has to be plugged for the longest time. Therefore, our demand has been that this is recognized and the severity of the penalty is increased, so that syndicates and groups which are actually taking it off the screen and kind of sending it out to the internet or other places are kind of discouraged from doing so. So I think I'm hopeful that it will probably go into the next session. My last conversation with the INB ministry was that they would probably bring it in the winter session, but then people have changed within the INB ministry, as we know. So hopefully now, if it happens as a combined session in January or in the end of January, along with the budget session, I'm sure there are a lot of bills which are going to keep people distracted, but this is just a small provision in the Cinematograph Act, which I think has been out for a long time, and hopefully it'll cross the line.
Great, thank you, Uday. The 1 hour has flown by. Again, my huge thanks to the panelists for your time today, for your contributions. It's been a really interesting exchange of views and ideas. We'll absolutely look forward to following these developments as we get into 2021 and hopefully finally put the pandemic behind all of us. So thank you again, and hope everyone enjoys the rest of the day during today's Vicky programming. Thank you.
Thank you.
Thank you, everyone.
Thank you.
Thank you,
Take care.
Trevor.
Bye-bye.